Good evening, everyone, and welcome to those who are watching at home on City Cable 5 and online. Thank you for joining us virtually in this virtual COVID world. Tonight's your chance to meet the candidates for municipal court judge. We have three of them who are finalists tonight. Appointing a judge to complete an unfulfilled term is not something that happens often, but it does happen periodically. And so tonight we're going through the process of community forum interviewing the final three candidates for the municipal court judge. Our process will be that these three finalists have been selected from an initial screening process, have gone through some vetting through community panels. So they've started out with 17 applicants and have gone through this process over the past couple of weeks. They're applying to fill the vacated seat by Judge Tracy Staub, who won election in November to the Court of Appeals. The Spokane Municipal Court is a court of limited jurisdiction with statutory authority to adjudicate criminal misdemeanors, civil infractions, and limited civil matters. And so these candidates have already been pre-screened for their technical abilities and for their qualifications and knowledge and ability to practice law in the state of Washington. So tonight, our focus is more about helping the mayor and the city council to determine who the best fit for the position is. The process for appointment of a position is the mayor appoints the candidate goes through a confirmation process by the city council. That process typically takes a week or two to complete, and our hope is to have that done by the end of the month. Our format for tonight will be that our candidates will have 3 minutes each to make an opening statement. I'll ask the first question as the moderator tonight, and I should introduce myself as well. My name is Brian Coddington. I'm the communications director for the city of Spokane. I'll ask the first question as the moderator. Each candidate will have 3 minutes to respond to that question, and then we'll open it up to community questions. For those of you who are watching at home and would like to ask a question, we do have a call-in process tonight. So if you haven't already gone online, if you go to my.spokanecity.org, click on the news button toward the bottom of the page, and then scroll down to the January 9th news release regarding the municipal court judge community forum. There's a link in there that you can click to ask a question. You'll have an option of either submitting the question in a written format that I'll read for you, or to be online and ask the question over the phone of our candidates. And each candidate will respond to the question that's asked, and they'll have 3 minutes to do that. So if you haven't gone on and signed up and you desire to do that, now would be a good time to do that. We'll leave that open until 4:30 this evening, and you'll have the opportunity to ask those questions if you desire. A quick little bit about our candidates before I turn it over to them. Each of them has been selected, as I said, through a process that's gone over the last couple of weeks. As far as our vetting process goes, they started the application process back in November and have worked their way through. Coincidentally, each of the three are local graduates. They've graduated from Gonzaga Law School. So we have three in alphabetical order: Deanna Kroll, Lyndon Smithson, and Kristen O'Sullivan. So I'm going to turn it over now to Deanna to deliver her opening statement. She's got 3 minutes to do that. Deanna?
Thank you, Brian. And as mentioned, my name is Deanna Kroll, and I thought I'd just take this time during opening to give a brief summary of how I came from a freshman at Gonzaga University undergraduate to how I'm here before you tonight applying for the position for the Spokane Municipal Court. So as I mentioned, I started out, my first experience with Spokane was in 1994. I went to the Gonzaga University undergraduate. I spent 3 years there before graduating and then applying to the law school. And I had the wonderful opportunity to be the first graduating class out of that brand new law school in 2001. In 2001, I was accepted to the Washington State Bar and became licensed. Once I was licensed, I was hired by the City of Spokane Prosecutor's Office. I was there temporarily to fill a position for an individual who was out on an extended leave, and then I was permanently hired by the Spokane County Prosecutor's Office. The time that I spent there, I focused mainly in the domestic violence unit, prosecuting those types of charges. A few years later, in 2007, I was invited to practice with a private law firm in town here that was going to be focusing on trial work. That was something that I was very excited to do and spent a lot of time doing. A few years later, in 2009, I joined the local downtown Spokane business community when I opened up my own firm. And I will be honest with you that practicing law and running a business are completely different. You don't go to school to learn the skills that are required for being able to run a business. But thank goodness I'm here 12 years later. It's been a wonderful experience. I've helped over 1,000 clients. I've been able to practice all over the state. And then for the last 18 months, I've actually had the privilege of being a pro tem judge. And when I describe what a pro tem judge is, I explain it's like a substitute teacher, but for judges. So when a judge is on holiday or they're out sick, they call me, and then I come in and I cover either infraction hearings, criminal proceedings, I handle civil matters, protection orders, and then also out in Airway Heights, I'm a pro tem judge for conflict matters. So when the judge has a conflict there, I handle that. And I can tell you that this experience for the last 18 months has just solidified that this is exactly what I want to do. And I look forward over the next hour to going into my philosophy and my mindset as to why I think I'm a good candidate for this. Thank you.
Thank you, Deanna. Lyndon?
Thanks, Brian. Good evening, everybody. My name is Lyndon. I currently work for the City Prosecutor's Office in Spokane. I started out at Gonzaga Law School. I graduated in 1998. From there, I worked at John Cooney Associates. I think it's now Cooney and Associates. Big John is retired, and one of the Johns are on the bench. But I worked there for a little while, representing criminal defendants. I then went to a small civil firm where we handled employment law matters, insurance defense cases. My employment law matters usually we represented people that were removed from their position because they were harassed or they were let go because of things like sexual orientation or their race, their gender, that type of thing. We represented quite a few people who were pregnant and had issues in their employment. So that was a time where I learned to practice law. It was a civil arena, so we did a lot of briefing. You study the law quite a bit. I learned to be a better lawyer there for sure. After that, I was asked to come over to the City Prosecutor's Office. I had some friends in that office, and they had a position in their domestic violence unit. The domestic violence unit kind of was akin to what I was doing in the employment arena, primarily focusing on issues where people are having issues because, in the domestic violence unit, they're assaulted by their partner. And so a lot of it kind of tied into my thinking on employment law issues, and I really enjoyed that. So I came over to the prosecutor's office. I eventually was head of the domestic violence unit, probably for about 10 years of the time I've been with the prosecutor's office. Been with the prosecutor's office for 17 years now, and I'm now our chief assistant city prosecutor. In that role, I basically make sure that I'm a liaison between different departments, the courts, probation, the police department, and I make sure that people are getting the things that they need, that the attorneys are able to make it to the dockets, that if they have any issues with what's going on in court, they let myself know, and either I handle it or the city prosecutor handles it. So I've been dedicated to the city for quite a while. I've been there 17 years. In my spare time, I coach youth soccer, and a lot of people probably notice me or know me from out on the fields. It's funny because some people know me from on the fields and they don't know that I wear a suit sometimes too. So usually they see me in shorts, but that's just a little bit about myself, and I appreciate that everybody has joined in tonight, and thank you, Brian, for this opportunity.
Thank you, Lyndon. Kristen?
Thank you, Brian. Good afternoon. First, I'd like to thank you all for attending the forum, and further thank the community members who served on the selection committee for their time and dedication to this community. My name is Kristen O'Sullivan. For the last 2 years, I've been a court commissioner with the Spokane Municipal Court. I seek this municipal court judge position due to my passion for this community. For the past 17 years, I have dedicated my career to criminal justice. After graduating law school, I worked as a deputy prosecutor for Benton County. My prosecution experience also includes Spokane County in a variety of units, and then the city of Spokane, where I was an assistant city prosecutor before becoming the chief assistant. In addition, prior to moving to Spokane in 2010, I was a criminal defense attorney in private practice representing clients in jurisdictions all over the state of Washington. I've been a clerk, I've been a prosecutor, I've been a defense attorney, and just as importantly, a judicial officer in the exact court that I seek to be a judge. I bring a balance of experience to the bench. I have presided over all types of hearings in Spokane Municipal Court, many which would be required as a municipal court judge, including many of our problem-solving courts such as DUI court, community court, and veterans court. As a court commissioner, I've handled responsibilities that would be required of me as a municipal court judge. I've proven that I have the demeanor necessary to be a judge, patience, empathy, and independence. I've proven I can communicate decisions with clarity in accordance with the law and court procedure, regardless of what side I'm ruling for. And most importantly, I've treated those before me with dignity. Further, I have proven that regardless of the situation, I will work hard, I will put in the time, and I have the desire to serve this community. I seek this position because I want to continue to hold individuals accountable for their actions, but also have the ability to encourage and support those in our community who seek change, whether it is a need for treatment, address mental health, or whatever the underlying factor is that is contributing to their involvement in our court system. See, it doesn't have to be one versus the other. It's about finding balance, a balance to keep the community safe, consider victims' rights, while restoring the individual with the goal to reduce recidivism. I will continue to acknowledge and address failures of those who continue to be disproportionately represented in our community due to race, mental health, substance abuse, and socioeconomic factors. I will continue to acknowledge and address implicit bias. I will continue to educate myself, promote communication, and participate in addressing court functionality. I will continue to be impartial. I will continue to support evidence-based practices and problem-solving courts. I will listen more, and I will continue to serve with dedication and integrity. It is these reasons why I seek this position. Thank you.
Thank you, Kristen. Appreciate all the opening statements. Before we go any further, we're going to enter the Q&A portion of our evening tonight. Just as a reminder for those watching at home and online, if you do want to ask a question tonight, visit my.spokanecity.org, click on the news link button, and find the news release from January 9th about the municipal court judge position. They'll give you a lot of background on the position itself, and there's also a link in there that allows you to sign up to ask a question. For those who may not want to ask a question tonight but might want to submit commentary after the fact, you can submit that to mayor@spokanecity.org. That'll go to Mayor Woodward, and they'll be shared with the city council as well as they make their decisions. So Lyndon will be first up for our Q&A. All the questions will go to each of the candidates, and they'll have 3 minutes to answer. So with that, our first question is, as you know, the worst problem facing our city is domestic violence. Do you have experience dealing with this issue? And if you were a judge, what will you do to make sure that victims receive justice? Lyndon.
Thank you, Brian. Domestic violence is a big issue in our community. I've been involved in the Spokane Regional Domestic Violence Unit, Coalition, and currently I hold a board position there. We have done some research. We released some numbers a couple years ago. There are about 3,000 cases in the city that are charged. There are another about 2,000 to 3,000 that are charged in the county. And then besides that, there are about 15,000 calls countywide for service for domestic violence. I have a lot of experience with it. I've worked with thousands of victims of domestic violence. I've heard their stories. I've helped them negotiate through the court system to get a resolution to their case. Obviously, we have to focus on the defendant mostly because that is who is causing the issue. The victim there, we are trying to help her out. Generally, I say her because overwhelmingly it's female who are assaulted. We try and get them services through the YWCA. The city of Spokane contracts with the YWCA for victim services. So we get them in touch with the YWCA. We are co-located with the YWCA, so it's easier for the victims to get into contact with a counselor or a victim's advocate to help them through the system. Going forward, we have a lot of work to do. We are not reducing our numbers. We need to keep working on that, and that's why I am part of the Spokane Regional Domestic Violence Coalition. I will continue my work with them. If I am appointed to the bench, I will renounce my board position, but I will continue to work with the coalition. I believe in the work that they do. They're doing a good job. but we need a little bit more time, a little more effort put into it to reduce the numbers. My vision for the future, I think that Spokane Municipal Court needs a domestic violence court, to be honest with you. We need to focus on these cases. They need to take a higher priority. We have other problem-solving courts, but we have not engaged and we have not put the resources towards domestic violence court. I think that's something that needs to be done in the future. So that would be one of my biggest goals if I took the bench. Thanks, Brian.
Thanks, Lyndon. Kristen, you're up next. What will you do to make sure that victims of domestic violence receive justice?
Sure. So just a little bit about my experience with domestic violence. I prosecuted cases as obviously a prosecutor. I represented individuals who were charged with domestic violence. And then obviously most recently as a court commissioner, we are responsible for handling criminal first appearance every day. Criminal first appearance means those individuals who have been arrested are entitled to a hearing. And at that hearing, we address safety concerns, failure to appear concerns, victim concerns, and we have to hold to the court rules, which presumes release of individuals and a presumption of innocence. I agree with Mr. Smithson. One of the things that I would like the court to explore is a domestic violence court. As he indicated, we have numerous other problem-solving courts, but we need to address the domestic violence in this community. Domestic violence is one of the most serious cases that we deal with in a municipal court. I have handled first appearance, I've handled pretrials, I've handled no contact order, motion dockets and modifications. And it certainly, as a judicial officer, are the type of cases that when you go home at night, you still think about and hope that you've made the right decision in accordance with the rules and that you've been able to articulate why you made the decision you did. It's a balancing act as a judicial officer because there is a presumption of innocence. However, we certainly, as a community, want to address domestic violence and ensure that we are protecting our victims. Thank you.
Thank you, Kristen. Our same question to you, Deanna. As a judge, how would you make sure that our domestic violence victims receive justice?
Yes, thank you. To touch briefly on what my experience is, as I had mentioned when I was with the County of Spokane in the prosecutor's office, most of my time was there prosecuting domestic violence cases, but also having the knowledge and experience not only representing individuals who are charged, but also on the bench. I think it's important that a judge has that perspective because although, yes, the normal is that a victim is female, I have seen time and again situations where maybe the male or in the same-sex relationship, they're victims. So I think it's important to be able to recognize and be open-minded that they're not always what it seems. I know that in Spokane County, we have one of the highest rates of domestic violence in the state. I think it's a prevalent problem that does need to be addressed. When I've been on the bench, I've addressed it when individuals come before me for civil protection orders. Maybe there isn't a criminal case going on right now, but they are the victim and they're seeking access to justice and protection that way. I've reviewed dozens of them, done several full hearings on them. A lot of them do have merit, and it's important that we take them seriously. The ones that don't have merit, it's important that as a judge you recognize that. Is there an ulterior motive here? What is that ulterior motive? Is there a family law issue? What's the struggle? But at the same time, I do agree with Kristen that it is a balancing act because I've also been on the bench and declined to remove a protection order because I think that regardless of what the victim's wishes were, she needed that protection. And then sure enough, a couple weeks later, there was a new charge against her husband and she was the victim. So sometimes it's making that tough decision that you need to step in and protect the individual when they're not ready to ask for that protection themselves. So I think that I do have all aspects of this situation. I think, again, it's important to keep an open mind. And that's what a judge should do. Thank you.
Thank you. And we do have a few questions coming in from the community now. Just as a reminder, for those of you maybe just joining us, we have about 10 minutes left on our time to open up to submit a question. So if you'd like to submit a question, please go to my.spokanecity.org, click on the news button, and then scroll down to the January 9th news release. There's a link in there to submit a question. If you'd like to submit feedback to this forum after the fact for the mayor or the city council, you can do that at mayor@spokanecity.org. So our question from the community, and our question is going to go first this time to Kristen, is a kind of a follow-up to the topics you were all just touching on related to domestic violence. And you touched on this a little bit, but we want to go a little bit more in depth, and this is a little more specific question. Would you support a domestic violence court as a mandatory court for repeat domestic violence offenders? Kristen.
Yes, I would. If you take a look at the statutes that we have in Washington, although we don't have mandatory court and municipal court, we have a DUI court for those individuals who are identified as high risk and high needs, those individuals who have more than one DUI in a certain time period. I think we should have the same for domestic violence. Obviously, they are a different type of case, and it is important that the individual who is going into the court is ready to make change, but it's made no sense to me that for DUIs, we have mandatory sentences for first offenses, second offenses, for driving a license suspended in the first degree, second degree, we have mandatory sentences. However, on domestic violence cases, we have no mandatory sentences. So I would support a mandatory domestic violence court for those who are repeat offenders. I think we have to hold those individuals accountable while offering support to make changes in behavior. The domestic violence relationship is such a complex situation dealing with power and control issues, and as a judicial officer, the goal is to keep the community safe and to reduce recidivism. So for those reasons, I do support a mandatory domestic violence court. Thank you.
Thank you, Kristen. Deanna, you're up next. Same question. Would you support a mandatory repeat offender domestic violence court?
I absolutely would. Some of the things that come along with mandatory courts are increased supervision, there's higher accountability, the court is able to maintain closer tabs, if you will, on individuals that are in those courts. At the same time, a court like that would be able to give tools and resources that might otherwise not be offered to the individuals who find themselves in that court. I know that a lot of resources are rightly so spent on the victims, the YWCA, finding housing, but I read just this last week an article where one of the Spokane police sergeants had gone through this program, I believe, where they went into the jail to sit down and talk with the individuals who had been arrested for domestic violence. And so I think that's the component that might be missing here that would help reduce the recidivism rate and, again, address the issue. So I absolutely do support a specialized court for domestic violence.
Thank you, Deanna. And then finally, Lyndon, same question to you. Your thoughts on the mandatory domestic violence court for repeat offenders?
Thank you. I would support a mandatory domestic violence court. I've been head of our domestic violence unit for about 10 years of the 17 years I've been at the office. I've been instrumental in driving the conversation on DV and our policies in the county, both the city and county prosecutors' offices, and we desperately want a DV court. We need a DV court. We need to go forward with that. In 1995, the state legislature addressed domestic violence cases. They gave us a domestic violence perpetrators program, and it was never really readdressed until just about 2 years ago. There was a very large coalition of legislatures, lobbyists, and quite a few people that worked on it in Olympia. They came out with a domestic violence intervention treatment program. I think it's an effective program. It's a better program than what we had now. We need to utilize it, and I think a domestic violence court would be better suited to help get people into the DVI-T program. We can have treatment reviews, whether those are weekly, bi-weekly, monthly, to make sure that people are involved in and engaged in treatment. We can check on the victims, make sure the victims are safe. determine whether or not that no contact order needs to remain in place or if it can be recalled at this time because the person is safe, and we can hold the offender accountable. Now, at the same time, holding somebody accountable isn't always a penalty. Sometimes it's just getting them back on track because they've maybe lost their job and don't have money to pay for the treatment. We understand that. We'll give them some time they can get back into treatment, or maybe it's just something that they don't have a way to get to treatment, and maybe we can facilitate that. So holding people accountable isn't always a penalty. It's making sure that they can get through the treatment that they are supposed to get through, and that in the end, they're better off for it.
Thank you, Lyndon. We have another question from the community. This one will go to Deanna first. If you're appointed, what will you do, if anything, to ensure that all of the treatment and alternative courts follow best practices and statistically document the impact each court has on the community? Deanna, three minutes.
Thank you. And I want to say I am a huge advocate of these alternative therapeutic courts. I use them as often as I can for my clients, whether or not it be veterans court, mental health court, intensive supervision for multiple DUI offenders. I think it's important that we recognize that it's not an individual taking advantage of this to have a better outcome in their case. Because honestly, and I've had to have this discussion with some other attorneys, it's requiring so much more of the individual. As I mentioned, there's increased monitoring. Instead of doing the standard treatment, maybe there's the mental health component. Or with Veterans Court, there's a mentoring program. And I think that the funds that these therapeutic courts get is important. And in order to maintain those funds, they do need to keep records. And so I would make sure, if I were appointed here and handling or supervising these therapeutic courts, that we do have those records necessary to be able to obtain those funds that are very vital for these courts to be able to run effectively. I've seen what they can do. I've seen the progress individuals make, and I think that they only need to expand from here. Thank you.
Thank you, Deanna. And finally, Kristen, same question.
Thank you, Brian. Like Ms. Kroll, I am a big proponent of problem-solving courts. Much of my time as a prosecutor in Benton County was working for drug courts with juveniles. My work with the city of Spokane included being a prosecutor in mental health court, helping create and implement a mental health diversion program. So I too support problem-solving courts. I truly think that they are the continued future of municipal court. With that being said, it is imperative that these courts utilize and use best practices. There are so many resources out there for drug courts, DUI courts, domestic violence courts, mental health courts that lay out the best practices of these courts so that they can have the most success for their participants. We need to make sure that we are utilizing risk needs tools. Those types of courts are aimed at high-risk, high-need individuals. Data shows actually if you put someone who is not high risk or high needs into a therapeutic court, it can actually do more damage. We have to have these programs also evaluated. For example, Community Court in the last few years had an evaluation done by Washington State University, which was evaluating how their program was doing, made suggestions. I would also support promoting ongoing training. It is important in these types of therapeutic and problem-solving courts that the teams, because it truly is more of a team setting, continue to educate themselves so that they are using the best practices and that it is supported. Back to having the programs evaluated, one of the most important things is to make sure that the program that you are utilizing is aimed at our community. What may work for LA isn't going to work for Spokane. So it is important to make sure that we are doing the best we can for our community members. We need to also review the data, look at what is working and what isn't working. Those are the things that I would suggest to continue our success with our problem-solving courts, to make suggestions if adjustments need to be made, because a lot of resources go into those courts. But I do think that it is resources well spent, and that it is the continued future of our court. Thank you.
Thank you. And I think I skipped over Lyndon. Is that correct? So,
Yeah, that's okay. That's right. And now I have no idea what the rotation is going to be, but you'll make it up.
Yeah.
In reference to these problem-solving courts, they're great. We have quite a few of them in the city. They have been working very well. In order to follow best practices, one, there has to be best practices. Sometimes we are such on the verge of a very new court, and we maybe don't have those best practices, and maybe we're even creating them. So in that instance, you need to get your team together. You need to have self-analysis, maybe quarterly meetings, maybe once every 6 months, but get together with your team, talk about what's working, how you can change. And I think the biggest thing is you can't be afraid to change. A lot of times we get into a rut and we decide that this is how we do things, and you do it for 5 years, and you look back and you're saying, wow, our recidivism rate is exactly the same, or it's worse. And so maybe we're not doing something correctly. We need to change what we're doing. And obviously you don't want to just change for the sake of change. You want to go out there and look for studies or the risk assessment tools, as Mr. Sullivan talked about. Our probation department is pretty good with it. They've got about 4 that they use. And so we can identify what the problems are in the population that we have, and to a person, we can decide exactly what their issues are and how we can best serve them going forward to keep them coming back to court. But absolutely, I support the therapeutic courts, the problem-solving courts. I'm in the mental health court right now. I run our program for the city of Spokane. What I've seen in that program is that with the help of case managers, people are able to go forward and have a lot of success, even though they have a lot of roadblocks, a lot of things that they have to overcome in order to be successful. But with the right resources and the right dynamics, they can be successful.
Thank you, Lyndon. My apologies for taking you out of order. To get us back on track, since Deanna took the last question first, we're going to get back to you, Lyndon, right away on the next question to take that one first as well. This question comes from the community. What is your stance on the new active probation model? What would you sustain and improve? 3 minutes.
Thanks, Brian. So we did have a presentation about 2 years ago by our probation department. They propped up a program, and to be honest with you, it sounded like a good program. Right now, our recidivism rate is between 76 to 81% in municipal court. That's not good. We need to do better. That's not acceptable, to be honest with you. So we need to work hard to get after that. In regards to the enhanced probation, we came up with a lot of tools that the probation department has. They have a CARS assessment, an ORAS assessment, a MAST assessment. We also have an ODARA, which is a domestic violence-related assessment. So we need to start using those. In my experience, working in the prosecutor's office, we were under the impression that these cases were going to be assigned to enhanced probation, and they just haven't been. So going forward, if I'm appointed to the bench, I can tell you that we will be using the enhanced supervision, the enhanced probation. I think it will be successful. I think it's a good model, and I think that going forward, I think it's underutilized right now, and we need to do a better job.
Thank you, Lyndon. Kristen, we'll go to you next. Same question about new active probation model. What would you sustain and what would you improve?
All right. Thank you. So I agree with Mr. Smithson. I think currently it is being underutilized. The court was met with some resistance in implementing it with probation. As a judicial officer, we want to target our resources to the high needs and high risk individuals. Those are the individuals that we are going to continue to see over and over unless we address the underlying issues. As a judicial officer sitting there sentencing someone, certainly we take input from the prosecutor, from the defense attorney. We take a look at criminal history. Is there a history of substance abuse? Is there a history of mental illness? However, for example, not every individual who gets cited with a DUI has an alcohol or drug problem. It's these risk assessments that are going to identify numerous factors, the driving factors as to why that individual finds themselves involved in the criminal justice system. It is if it's just a judge taking a recommendation from the parties, we need to have meaningful sentences and meaningful probation. As I think Ms. Kroll indicated, our problem-solving courts or our more enhanced supervision of probation allows our probation officers to truly not only monitor, but to be an advocate for change, whether it's addressing housing issues, whether it's addressing getting on medical insurance, driver's license, substance abuse, mental health issues. It's all those factors that we need to take into consideration as to why the individual is finding themselves involved in the criminal justice system. So I do support it. I think it is being underutilized, and I would encourage the parties to make recommendations for evaluations more and have meaningful sentences for those individuals who appear before me. Thank you.
Thank you, Kristen. Deanna, same question to you. Your thoughts on the probation model and what you would improve and what you'd sustain?
I agree with both of the other individuals that when you have an approach that narrowly tailors and recognizes what an individual needs, then there can be a better program set up for them, better monitoring, and monitoring for what those issues are. And as been alluded to, say in mental health court, there is that close supervision. They're making sure that not only is there the standard component of a treatment, say, I'll call substance abuse treatment, but they're making sure that there's that mental health component as well. So I would agree that having a more aggressive, more adaptive and tailored probation would be important to be able to address and hopefully reduce that recidivism rate that Lyndon was speaking about. I do want to say, though, that in my experience, I do think that the Spokane Municipal Probation does a very good job. The individuals there, some of the differences that Spokane Municipal Probation has is they have better access for those that don't have financial resources. I know a lot of times people who are indigent, they cannot afford alternatives to confinement. They may not be able to afford the restrictions to be able to have a driver's license. But what I've seen is that the Spokane Municipal Probation provides these monitoring devices at a very low, if not no cost. And so I think that their ability to do that, coupled with changing these practices to make them more specific to the individual, really will go hand in hand to make a difference. But I did want to acknowledge that I think that they do an excellent job. They're very proactive when it comes to monitoring individuals who are in pretrial conditions. And so that's what I would say. Thank you.
Thank you, Deanna. Kristen, the next question will come to you first. And the question is, do you believe that implicit bias exists in our criminal justice system? How do you see it manifested, and what will you do as a judge to reduce its impact? 3 minutes.
Thank you. Sorry, I had a little delay there in unmuting myself. Yes, I absolutely do believe implicit bias exists in our system. As I indicated in my opening statement, it is apparent that there are individuals in our community that continue to disproportionately be represented in our criminal justice system, whether it's based on race, whether it's based on mental illness, whether it's based on substance abuse or socioeconomic issues. One of the things as a community court that as a municipal court that we try to do is first educate ourselves. We've attended new trainings through Just Lead. We've been very receptive to having those hard types of conversations. In addition to educating, I think you have to acknowledge, yes, there are implicit bias that exist in our system. The third thing I would suggest is listening to those community members, listening to the other stakeholders. I know myself as a judicial judge, I have created an internal check for first appearance or when I'm handling any type of court appearance to make sure that I am consistently and equally applying the law as it pertains to anyone that appears before me. Those are the things that we have done to this point. There is still a lot of improvement to be made, But I would continue, again, to educate, support change, and mostly listen to the community. Thank you.
Thank you, Kristen. Deanna, you're up next. Same question.
Thank you. And I do agree. I do believe that there is an implicit bias that does exist. And I agree that there needs to be a multiple approach here. You do need to listen. You need to also take what you hear and try to understand and recognize what the issue is. Is it, again, financial? Is this a crime that continues to reoccur because this individual is homeless? Do they need resources? Is this a situation where they have mental health issues? So it's very important to look and see what is underlying here and how can we address this to alleviate that bias. I know that some changes came down recently in the last few years that give judges a little more leeway when it comes to fines and fees that are levied upon individuals. And I think that helps alleviate some of that when judges utilize it. And I think that they should utilize it more because then that will address part of that financial burden that's disproportionate to the individual. I think that a judge also, when it comes to bias, needs to lead by example, meaning set a good example, treat everybody equally with respect. And then by doing that, hopefully in turn, that's the type of atmosphere that your court reflects. And so I do believe that there is bias in the system and that a judge has a crucial role to be able to address that and impact it.
Thank you, Deanna. And finally, Lyndon, same question regarding your thoughts on implicit bias.
Thank you. I think we have to initially just acknowledge that, yeah, there's minorities are overrepresented in our criminal justice system. We do have the SRLJC that works in Spokane to alleviate these issues and identify them and work with all of the stakeholders, all community members. My boss is a chair of that committee. I go to those meetings, and they're effective. They're being effective. Things that we need to look at. We need to increase access to justice for both victims and for defendants. What does that look like? We need to work on that as a county and as a system-wide. We need to improve the jury pool representation. I think this probably comes down to education. People are extremely intimidated by the court system. They're intimidated by going to jury duty, and so probably people that, especially immigrant populations, probably are extremely afraid of going down to the courthouse to go to jury duty. We need to promote diversity in all throughout the court system. We need to provide adequate interpreter services. The Spokane City does a very good job of that. We have interpreters, and Mr. Sullivan, when she's on the bench, if somebody says they need an interpreter, she gives them access to interpreters, and we do a good job about that. So that's one barrier that we're removing that we're doing a good job at. We need to continue education programs. I think we need to be reaching out to the colleges and the law schools and trying to help increase diversity throughout our legal profession. Mentoring, I think, is a big key to that as well. So, but I think initially we have to acknowledge that yes, that the SRLJC showed that people of color are twice as likely to be represented in the criminal justice system before trial, and once after trial, they're still higher than the average incarcerated, higher than the population in the county of Spokane. So we still have more work to do. Thanks, Brian.
Thank you, Lyndon. So the next question, we're going to start with Deanna this time. Please explain your views of the application of Rule 3.2, which governs the requirements of release. Deanna?
Thank you, Brian. 3.2, I think, has gone through some tailoring over the last few years. It's a balancing when an individual comes before me at arraignment or they've been picked up on a warrant and their first appearance. The question is, should they be released to the community? And the components of that are whether or not the individual is a risk to the community. Will they reoffend? Are they likely to appear for court if they are released? And what goes into that is also a look at what their financial ability is. Is it a reasonable bond that's been put in place? I think it's important to note that the first approach should be to OR an individual to release them into the community. But then again, you have to look at what their criminal history is. You have to look at the nature of the crime. You have to look, again, are they going to come to court? Do they have stable housing to get notification or a place to reside that's maybe not with the listed victim? So I think 3.2 has become more narrowly tailored over the last few years, and it's important to apply it specifically to each individual rather than to have a blanket application of this, because every situation is different, and that's how I think 3.2 and how I utilize 3.2 in the courtroom for individuals.
Thank you, Deanna. Lyndon, same question regarding requirements of release.
Thanks. I've been working with Rule 3.2 for about 20-some years now. I've argued it as representing criminal defendants. I've argued it as a prosecutor. It is, as Ms. Kroll stated, it's the rule that determines whether or not somebody is released from jail after they're arrested. And just for people that are not involved in the legal community, the two things that can be argued to hold somebody is whether they will not come back to court or if they are a threat to the community safety. And so there are definitely a lot of sub-factors to that, but those are the two things that it come down to. And so from the bench, you have to weigh the argument from both sides, and obviously the rule now presumes that release is the first course of action, and then if there are points basically against the person, then they might be held and set a bond. The problem that from the bench and the difficulty is that all you have is the information from a police report and possibly their criminal history. So it's extremely difficult. We don't have a lot of those risk assessment tools that we talked about that we get on probation. You don't have it up front. So it's extremely difficult for people on the bench, and Ms. O'Sullivan does a great job in it day in and day out. But I know that it's difficult, though, to make those decisions when one person is asking that they be held and the defense is asking that the person be released. So I've worked with it a long time. I've seen it from both sides, and now I'm prepared to be on the bench and handle it as a from the middle.
Thank you, Lyndon. Kristen, finally, your thoughts on the release requirements rule.
All right, thank you. As a court commissioner, we use 3.2 every day. That is one of our main responsibilities. As I indicated in my opening, is handling first appearances, which are those individuals who are in custody, who are at their very first appearance. As Mr. Smithson indicated, first, the presumption in all non-capital cases is released. There are two prongs in which the court has to consider. The first would be, is there a likelihood that that individual is not going to show up to court? There are several factors that the court has to take into consideration, such as ties to the community, how long they've lived in Spokane, is there a community member that's there to vouch for them? Are they in treatment? Are they in school? Do they work? Do they have prior failures to appear? Do they have prior convictions for fugitive warrants or extradition warrants? So the court takes a look at that first prong and makes a determination whether there's a likelihood that they will not show up. The second prong is there a substantial danger that that individual is going to commit a violent offense, interfere with the administration of justice, or intimidate a witness? Several of the factors that we consider in determining that, again, is criminal history. Are there crimes of violence on their record? Are there crimes involving weapons? Are there prior convictions for intimidating witnesses? With domestic violence cases, we certainly take into consideration whether there's been unreported domestic violence. One of the good things that we are typically provided at first appearance in domestic violence cases is the lethality protocols that the officers administer on an alleged victim at the scene. There are certain questions that they administer at that time. And those give the court great insight as to whether there have been those red flags of unreported domestic violence and the lethality protocols that could potentially exist. Even if the court makes a determination under either of these prongs, the court rule still requires us to address least restrictive means. So for example, in a domestic violence case, if we can still release that individual and address the conditions of release, we could put a no contact order in, we could use GPS monitoring. And so those are the things that we have to consider with regards to 3.2.
Thank you, Kristen. Appreciate all the answers. We've wrapped up our Q&A portion. We're going to shift to our closing statement piece, and we're going to start with Lyndon on the closing statement. As a reminder for those of us watching at home, we have 3 minutes for each of the candidates to deliver closing remarks. You can recover any questions you wanted to cover or anything else that you'd like the community to know about your career and your fit for the vacant seat on the municipal court bench. So Lyndon, 3 minutes.
Thanks, Brian. I think I just want to let everybody know that the reason I'm seeking the position on the bench is it's my dedication to the community. It's my community service that I currently do through coaching youth soccer. I work for the city prosecutor's office. I want to keep going with that. I want to take it to the bench. I think that I have the requisite tools that they've gained over 20-some years of practicing law. I think that I have the demeanor to handle cases, and I don't lose my temper with people. I can be reasonable with people and listen to both sides of an argument. I think also for a judge, you need to be willing to learn all the time. You're going to have extremely intelligent attorneys in front of you making arguments from both sides, and you may go into a situation where you think you know how you're going to rule on a situation. And once you hear the arguments, you might change your mind. You have to be open to that. That's what a judge is supposed to do. They're supposed to be open. They're supposed to be non-prejudicial. They have to listen to both sides and then make the determination that is best for the person before them. Because when it comes down to it, the defendant is who has the rights at the time when they're standing in front of you. They're the person that is looking at going to jail or not, or having penalties as by way of monitoring or probation or treatment or jail as a last alternative. So I just ask that I be given this opportunity to move my career forward, to serve the city, serve the community from the bench, and to do the best that I can. Thank you.
Thank you, Lyndon. Kristen, you're next. 3 minutes.
Thank you, Brian, and thank you for moderating today, and thank you all of you who have joined us for your time and interest in this process. I'm going to take the last couple minutes just to share my visions and hopes for the future of the municipal court. First, one of the things that I would love to address is we must keep accurate data. We must keep it in a manner that is easy to access, to interpret, and to review. Data assists us in addressing procedures and processes. It helps assure transparency and public confidence. With review of data as a court, we can better allocate our resources, improve overall access to justice, and reduce recidivism. While the pandemic has further complicated court processes and court appearances, once this pandemic subsides, we need to address the failures to appear for hearings. We need to readdress our book and release procedures, court procedures in general, to continue to utilize where we can technology, saving time and resources. We need to continue to evaluate how best to address those with mental health and substance abuse needs. This is the driving factor with so many people that we see in court every day. Judicial independence is important, and it is essential, but it is not the judicial officer's only obligation. It is important for the stakeholders and branches of government to communicate, to build working relationships, and to honor that each of us has the respective roles for overall improvement. I want the municipal court to continue to lead with innovation, to continue to be receptive to change, and continue to strive to make sure that all in our community better experience justice. Last, I assure the community that on day one, I will be ready to serve with grace, humility, and integrity. And again, thank you so much for your interest and time in this process.
Thank you, Kristen. And lastly, we'll hear from Deanna. 3 minutes.
Thank you, Brian. I want to just reiterate that I've devoted my career largely to criminal law, both as a defense attorney for indigent individuals, as well as a prosecutor, and now I've worn the hat as a pro tem judge. I believe I have a unique perspective having private clients because I'm able to not only experience their diverse backgrounds. I have a large population of first and second generation immigrants that are my clients. I've represented individuals from numerous different countries, but I also believe it's important that I'm able to see what happens outside of the courtroom and the practical impact that it has on their lives. I also have trial experiences with cases ranging from driving offenses to violent felonies and homicides. And I mention that because I think that's a foundation of understanding that only comes from having the experience of being in trial, because part of the position is also, do you have the information to translate into jury trial management, efficiency skills, and that's part of what the position is looking for as well that we didn't address yet tonight. I believe that it's important that I have been in courtrooms all across the state, and I've seen the qualities that good judges have. And I think it's more than just experience and qualifications, because we're all experienced, we're all qualified. That makes somebody a great attorney. It doesn't necessarily make them an excellent judge. The other component that I think that needs to go into it is having the right mindset. And what I mean by that is to look at the individuals that come into your court, not as cases, but individuals. They may have an infraction case, but that infraction case is important to them. And to have respect for the individuals that are there. It's not just the administration of the cases, the justice, it's also administration plus the opportunity to have a positive impact. And whether that impact be on the individual or that impact be on the community, it needs to be positive. And it requires balancing, a balancing of time and resources, a balancing of whether or not to have an individual engage in programs, treatment, hopefully get the tools that they need so they're not back before the court, or whether or not it's the balance of looking for the community and protecting them, that they need to have the positive impact there. Maybe the individual does need to be taken into custody. So I believe my mindset is an excellent fit for this, and I thank everybody for their time tonight.
Thank you, Deanna. And thank you to all three candidates. We appreciate your candidacy tonight and your willingness to meet with the community and spend some time getting to know you and for the community to ask some questions of you. On behalf of the mayor, Mayor Woodward, and on behalf of the Spokane City Council, we appreciate the community tonight. Your engagement in this process is critically important, and your time is a very, very valuable asset for each of the elected officials who are going to be weighing in on this decision. The mayor will take a few days to consider her options and her decision. She'll meet with each of the candidates individually, and she'll consider the feedback that she receives tonight from the community. For those of you who would like to submit any written commentary to the mayor or to the city council, you can do that at mayor@spokanecity.org. That's mayor@spokanecity.org. The city council confirmation process, once the mayor has made her appointment, will take a couple of weeks typically, so our hope is to have that done by later this month. The council will go through that process at a public meeting, and the community will be informed of the decision at that point in time. So thank you again for everybody. Have a good night, and if you have comments, mayor@spokanecity.org. Thank you very much. Have a good evening.
Thanks, everybody. Thanks, Brian. See you, Kristen.
Thank you all.
Thank you.